Hey everyone, welcome back to the channel. Today we are diving deep into something that can save you both time and money if you ever find yourself in a legal dispute. The Simplified Civil Process under Order 65 of the Singapore's Rules of Courts 2021. Think of it this way. Imagine you're owed $40,000 by someone, but the idea of going to court feels overwhelming. The legal fees, the time, the stress. Well, Singapore's legal system thought about that too and introduced a streamlined process just for situations like this. The Simplified Civil Process under Order 65 is like a fast-track lane at the airport, designed to get you through the system faster, cheaper, and with less hassle. It's tailored specifically for smaller civil claims, typically under $60,000 in the Magistrates Court or between $60,000 and $250,000 in the District Court, if both parties agree to use this process. But why was this process introduced? Before 2014, even small civil claims had to go through the same complex procedures as million-dollar lawsuits. This often meant high legal costs and long trials, making people think twice before pursuing what was rightfully theirs. Recognizing this problem, Singapore's judiciary introduced the Simplified Civil Process, designed to make justice accessible without the hefty price tag. In 2021, the new rules of court were enacted, and the Simplified Civil Process was formally codified under Order 65. So what's the point of this process? The purpose is straightforward: to offer an efficient, cost-effective, and fair resolution for less complex civil disputes. The origin of the simplified process stems from a legal philosophy called proportionality, the idea that the complexity and cost of litigation should be proportionate to what's at stake. It doesn't make sense to spend $30,000 on legal fees fighting for a $40,000 claim, correct? The rationale is about balancing the scales. The legal system should serve everyone, not just rich corporations or individuals with deep pockets. By simplifying procedures, the courts are ensuring that justice remains accessible to ordinary people and small businesses. Justice delayed is justice denied. Now let's talk about who can actually use the Simplified Civil Process. Under Order 65, here's how it works. If your claim is up to $60,000 in the Magistrates Court, it automatically qualifies for the Simplified Process. If your claim is between $60,000 and $250,000 in the District Court, you can still use the process if all parties agree. However, some cases may not be suitable for the Simplified Process, such as complex commercial disputes, cases involving fraud, or claims that require extensive evidence and expert testimony. Think of it like this. If the legal issue is straightforward, like a debt claim or a simple contract dispute, the Simplified Civil Process is your go-to. But if it's a complex matter involving multiple parties and intricate legal questions, it's probably better suited for the regular civil process. Let's get technical for a moment. The Simplified Civil Process is governed by Order 65 of the Rules of Court. This new set of rules was enacted to streamline court procedures and make litigation more efficient. Now, the Simplified Civil Process comes with great features that make life easier for everyone involved. Here's how it works. Both parties are required to exchange all documents up front, no surprises down the road. This ensures that everyone knows the key facts and issues early in the case. If you are suing someone for unpaid rent, both sides would exchange tenancy agreements, payment receipts, and any communications upfront. The process is designed to minimize unnecessary court appearances. Many matters can be handled through written submissions or virtual hearings, saving time and money. Instead of attending multiple pre-trial conferences, the courts may combine matters into a single hearing. Trials under the Simplified Process are also less formal and typically shorter in time. The judge may even decide certain issues based on written submissions without the need for oral evidence. For a straightforward contract dispute, the judge might even decide the case solely on the documents submitted. Furthermore, the rules place limits on legal costs and disbursements to prevent legal fees from spiraling out of control. Lawyers cannot charge exorbitant rates for simplified cases, and court fees are generally lower. The benefits of the simplified civil process include affordability, as lower legal fees and court costs makes it accessible to individuals and small businesses. It is also efficient, allowing faster resolution of disputes, with cases typically resolved in months, not years. The system is also more accessible, making it easier for self-represented litigants to navigate the whole process without feeling overwhelmed. It also reduces stress, as fewer court hearings and simplified procedures significantly ease the emotional burden of litigation. And here's a fun fact that most people don't realize. 85% to 90% of cases under the simplified civil process actually get settled out of court during mediation without ever going to trial. That's right. The system is designed not just to streamline trials, but to avoid them altogether whenever possible. Mediation is a voluntary process where both parties sit down with a neutral third party, the mediator, who helps them reach a mutually acceptable agreement. It's informal, confidential, and way less stressful than a court trial. It saves time, as cases that might have dragged on for months can sometimes be resolved in a single mediation session. It also saves money, as there's no need to pay for lengthy legal proceedings and trial. It preserves relationships, which is particularly important for disputes involving business partners, landlords and tenants, or even family members. You can watch my earlier video on mediation, the link is below. The courts actively encourage mediation under Order 65. Judges can direct parties to mediation, and in many cases, parties voluntarily agree to it because they see the benefits. So if you are heading into a simplified civil case, there's a good chance you'll walk away with a resolution without ever stepping foot in the courtroom. Now let's get real. The simplified civil process is fantastic in many ways. It's not always the perfect fit. It's great for straightforward cases like debt recovery, simple contract disputes, and tenancy disagreements. However, it's not ideal for complex cases that involve multiple parties, large amount of evidence, or significant legal questions. Think about corporate disputes or cases involving fraud. The beauty of the system is that it gives parties options. If both sides agree, even higher value claims can be resolved through this simplified process, saving everyone time and money. But remember, the goal of any legal process should be fairness, not just speed. Sometimes, taking the longer route ensures that every issue gets the attention it deserves. And there you have it, the simplified civil process under Order 65 of Singapore's Rules of Court, a legal tool designed to make justice more accessible, affordable, and efficient for everyone. And remember, with mediation resolving almost 90% of cases, there is a good chance you'll never have to face the stress of a full trial. If you have any legal questions, drop them in the comments below. Until next time, stay informed, stay empowered, and remember, justice should be for everyone, not just those who can afford it. Thanks for watching, and I'll see you in the next video.